I was unable to make it to Salem the other day to testify on the gun bills that were being heard in the Senate Judiciary Committee hearings, and I feel bad that I couldn't make it, so I figured the least I could do was make a YouTube video of what would have been my testimony in hopes that some of the people on the committee can see the video, in particular Senator Arnie Roblin, because I think I approached this issue from sort of a different point of view than what a lot of the other people are saying. And what I'm going to talk about can also be used on a federal level or in other states as well. So please feel free to share this video around because, once again, I think I approached the issue from a different point of view. My testimony was based on Oregon Senate Bill 700, which is the bill that would require mandatory background checks even for private firearm sales. One of the fundamental principles that our legal system is based on is the presumption that one is innocent until proven guilty. The burden of proof lies with who declares, not with who denies. To require background checks for private firearm sales, one is basically saying that every potential buyer is guilty and they must prove their innocence in order to own an inanimate object. As Representative Jessica Vega Pederson said when asked about this, we have to check to see if they are guilty. The 14th Amendment to the U.S. Constitution says no state shall deprive any person of life, liberty, or property without due process of law. Due process, of course, has its roots in the notion that the onus is on the accuser to prove the guilt, rather than the accused having to prove their innocence. Even the United Nations Declaration of Human Rights, Article 11, states that we have the right to be presumed innocent until proven guilty. And later, Article 30 states, nothing in this declaration may be interpreted as implying for any state, group, or person any right to engage in any activity or to perform any act aimed at the destruction of any of the rights and freedoms set forth herein. By making an assumption that everyone is guilty to begin with and must prove otherwise sets a dangerous precedence. This is similar to the unconstitutional DUI checkpoints that some local law enforcement agencies have set up across the nation. They pick a point on the road and they force every driver to stop and prove they are not drunk. If you follow this path, what's to stop other random checks to see if someone is guilty? Would an officer or other governmental law agent be able to stop anyone driving without just cause for the mere purpose of checking to see if they are guilty of anything? Would they be able to stop random people walking down the street as a means test of sorts to see if there are warrants out for them or to check for illegal items? An officer or governmental agent must have just cause to believe that someone has committed a crime, otherwise that person is innocent. SB 700 would make it a crime to not prove innocence. Let me repeat that. SB 700 would make it a crime to not prove innocence. West's Encyclopedia of American Law has a line that reads, "The presumption of innocence is essential to the criminal process." And also, the people of the United States have rejected the alternative to a presumption of innocence as being inquisitorial and contrary to the principles of a free society. Thank you very much.